Thank you for having me. My name is Lauren London. I'm the General Counsel here at Eastern. And my talk tonight is a really hard talk to give. As excited as I was to be asked to speak about the First Amendment on campus, and as interesting a topic as it is, both to me professionally and personally, it's a really hard sell. We are a campus that is rooted in diversity and inclusion and expansive thought and social progress. And in recent years, the debate around free speech has put our values at odds with the very Constitution that got us to this point. It's an uncomfortable topic to discuss with each other, particularly among people who have been hurt, people who have been victims of hate speech or other awful conduct here or elsewhere in their lives. But nonetheless, it's an important topic, and it's one that we and other public universities continue to face every single day. It's important to know how important the First Amendment continues to be in the country and why we still value it, and also the parameters of the law so that we know how to act within it and to do what we can to promote the atmosphere that we want to see in the world and to even make the change that we want to see in the world. Also, before I really get going, I'd like to issue an important warning. In this talk, I will make reference to some disturbing imagery and some disturbing thoughts and events, particularly the messages of white supremacists and others whose views I vehemently disagree with. As a member of a religious minority, these views are incredibly disturbing to me personally, as I'm sure they will be to many of you, and they can even be triggering. It is nonetheless vital to discuss them here because they are often the center point around which free speech doctrine is being built in this country. They represent today an area where the Constitution and the foundation of our democratic system and law in America clashes with some civic progress that we have made in our belief system that has been developed and hard-won over the last 240 years. On August 11th, 2017, in Charlottesville, Virginia, a federal judge ruled that a Unite the Right rally headed by Richard Spencer, who was the director of the white nationalist think tank, the National Policy Institute, could be held in Charlottesville's Emancipation Park. At approximately 8:45 p.m., a group of 250 white supremacists and nationalists assembled on Nameless Field, which is kind of an odd name, Nameless Field, which is located at the back of Memorial Gymnasium at the University of Virginia. The group, which was led by Richard Spencer, then marched to a statue of Thomas Jefferson, where a small group of counter-protesters who were UVA students had locked arms around the statue to protest the white supremacists. The clash turned violent, and the groups traded shoves, punches, and they sprayed chemical irritants at each other. Early the next morning, Unite the Right rally participants, some of whom were chanting racist and anti-Semitic slogans and carrying, in some cases, semi-automatic rifles and brandishing swastikas and other Nazi paraphernalia and anti-Muslim paraphernalia, assembled throughout Charlottesville, through the downtown area of Charlottesville. The violence continued to escalate with marchers and counter-protesters swinging weapons at each other, punching and spraying chemicals. At about 11:32 in the morning, law enforcement officials ruled it an unlawful assembly as violence broke out. At 11:52, Virginia Governor Terry McAuliffe declared a state of emergency. At 1:42 p.m., a car later identified as belonging to James Alex Field plowed into a downtown mall, killing counter-protester and Charlottesville resident Heather Hager and injuring 19 others. Just days after this rally, Richard Spencer went on a university speaking tour around the country, applying to public universities for the chance to speak on their campuses. Why public universities? Because Spencer knew that they, unlike private universities, are arms of the state government and thus are subject to constitutional obligations to protect free speech. Among those he petitioned were Auburn University, Texas A&M, Michigan State University, the University of Florida, Louisiana State University, Ohio State University, Penn State University, and the University of Michigan. The universities responded in various ways. Some, who were afraid of violence on campus and were bowing to public pressure, both from students and from some faculty, refused him space. In response, Spencer sued, arguing that the schools violated his right to free speech as guaranteed under the First and 14th Amendments of the U.S. Constitution. Others allowed the requests and went to great expense to let the speech proceed in as secure a manner as possible, all the while churning out press releases, videos, and statements, and holding campus forums, touting their commitment to diversity and inclusion and their hatred for Spencer's message. Still others, notably the university down the street, prolonged their consideration of the request, prompting community-wide debate of the constitutionality of a potential refusal and leading to threats of further lawsuits from Spencer's camp. In every case where Spencer did file a lawsuit, and he didn't sue the University of Michigan, but at Auburn, Penn State, Ohio State, and Michigan State, where he did sue, in 3 different federal circuits around the country, he won the right to speak in every case. More than that, the courts all ruled that Spencer could not be charged for any additional security for any additional security costs that his speech would necessitate. What's going on here? Why, in the wake of incidents like what happened in Charlottesville just days later, does this hateful person get to intrude on college campuses where the protection of values like diversity and inclusion and a devotion to non-discrimination is vital to what we do? I'd like to take a few minutes to talk about the foundations of constitutional free speech in this country, how free speech evolved on college campuses, and to look at some of the issues that courts are facing now. So where does the notion of free speech come from, and why is it rooted so steadfastly in our society? We have hoisted it up on this pedestal as being essential to our way of governing in the world. Why is that? Well, there are many reasons, but chief among them, I think, is the fact that it allows the majority view to evolve over time. People need ways, other than government proclamation, to learn about and freely comment on how the government is working. One of the founding principles we rely on in our daily lives is the fact that we can openly criticize one another and the state, largely without fear of being arrested. Government censorship of private citizens largely cannot exist here. And this right is so plain to us that we often take it for granted. Compare that with some other countries where, for example, you can be arrested for speaking ill of the government or of its leader. Anyone who listened to, for example, NPR reported from North Korea this week. They sent reporters to North Korea who were led around, and you heard many times throughout that reporting just how careful North Korean citizens are when they talk about their supreme leader and about the government of that country. That is a government where this right does not exist. But back to us. Since the beginning, as our country grew, some great thinkers helped to illustrate why we put freedom of speech on the very first amendment to the Constitution in the Bill of Rights. Here's labor leader Samuel Gompers. Here's the quote: "The freedom of speech and the freedom of the press have not been granted to the people in order that they may say things which please and which are based upon accepted thought, but to say the things which displease, the right to say things which may convey new and yet unexpected thoughts, the right to say things even though they do a wrong. And of course, Supreme Court Justice Oliver Wendell Holmes said, if there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom of the thought that we hate. And here's Benjamin Franklin. This one might be my personal favorite. If all printers were determined not to print anything till they were sure that it would offend nobody, there would be very little printed. He also said that freedom of speech is a principal pillar of a free government. When this support is taken away, the constitution of a free society is dissolved. So free speech exists to prevent censorship and protect the minority view, to empower those who don't represent the state or the government's professed view on a topic to speak their mind and try to make change. And the Founding Fathers thus enshrined free speech into the Constitution, and here's the language right from the document. Here it is. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging freedom of speech or of the press or the right of the people to peaceably assemble or peaceably to assemble and to petition the government for a redress of grievances. That's the US Constitution. And here's the Michigan Constitution, which is a little bit plainer spoken. Every person may freely speak, write, express, and publish his views on all subjects, being responsible for the abuse of such right, and no law shall be enacted to restrain or abridge the liberty of speech or of the press. That's Michigan Constitution of 1963, Article 1, Section 5. These are pretty simple and they're short. It's extremely basic language, and it largely leaves it to interpreters, the people and the courts, to tease out what's protected and what's not. And over the years, some parameters have grown up around what's protected and what's not. Several Supreme Court cases have set these parameters, and courts continue to shape them today. So here are some of the basic rules around freedom of speech that has been established by the Supreme Court. So first, we're going to look at what's protected. Here's Supreme Court Justice Thurgood Marshall, who says it better than I ever could. He says, quote, if the First Amendment means anything, it means that the government may not prohibit expression because of its message, ideas, subject matter, or content, end quote. What does that mean? It means that in general, we can't stop someone from speaking simply because of what they plan to say. We may find the message absolutely abhorrent, but we can't use the fact that it's a message we hate to shut it down completely. Next, we can't shut down speech simply because we think it will have an adverse effect on the listener. This is called the Hecklers Veto. Has anybody heard of the Hecklers Veto? The government can't shut down the speech simply because you might be offended by what you hear. That would amount to granting power to the heckler, to the audience, to silence someone before they start. And thus, the government's fear that the audience might react badly can't be used in that way. Think of Benjamin Franklin's quote about the printers. There would be very, very little printed if we were afraid of offending people. Freedom of speech also protects some nonverbal expressive conduct. Perhaps the most famous freedom of speech case ever to involve education involved nonverbal conduct. Has anybody heard of Mary Beth Tinker in the room? Yeah, a couple, yeah. So we're going to talk about her. In 1965, there were numerous protests against the Vietnam War. And I asked, by the way, about Mary Beth Tinker because the family is from this area. And I think they have been reported on locally in terms of who's still here and who's not. Anyway, there were numerous protests against the Vietnam War in 1965. There were many public demonstrations and teach-ins happening. And on December 16th, 1965, Mary Beth Tinker, who was 13 years old, She was a student at Warren Harding Junior High, at the time in Des Moines, Iowa. Wore a black armband to school with a peace sign on it in order to protest the Vietnam War. After lunch that day, Tinker was called to the principal's office and suspended for violating a district ban on armbands. They actually had a ban on wearing armbands at school. After a week, 4 other students, her sister Hope and her brothers John and Paul, along with Christopher Eckhart, were also suspended. The school board president defended the ban as a disciplinary measure against a disturbing influence in the school. Quote, "Our country's leaders have decided on a course of action and we should support them," end quote. The school board upheld the ban, but the Tinkers sued and their case went all the way to the Supreme Court. Although the trial court upheld the ban, the Supreme Court reversed it, voting 7-2 to strike it down. In that decision, Justice Abe Fortas famously said, "It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate." The court went on to rule that in order to justify censoring speech, officials must be able to show that their action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompanies an unpopular viewpoint. Student speech cannot be censored unless it materially disrupts classwork or involves a substantial disorder or invasion of the rights of others. Because the Tinkers' armbands did not cause that kind of disruption, their activity represented constitutionally protected symbolic speech. More nonverbal conduct. In 1989, the court found that the act of burning an American flag without more, in and of itself, is protected speech under the First Amendment. The court used the same reasoning, saying expression may not be prohibited on the basis that an audience that takes serious offense to the expression may disturb the peace, since the government cannot assume that every expression of a provocative idea will create a riot, but must look at the actual circumstances surrounding the expression. Meaning, you can't just say it's flag burning, you have to look at the entire circumstances surrounding the action. And then, of course, as we discuss nonverbal speech today, Colin Kaepernick's case comes to mind as well. Although the NFL, it should be noted, is a private organization and is not public, so it can technically make its own rules, it's hard to ignore the import of First Amendment precedent when you see that situation. And then also in the recent case of the woman, the bicyclist who flipped off the presidential motorcade, you guys remember that case? So she worked for a government contractor and was fired for doing that. She has sued her employer, and that case is currently pending. Also, as we're at a university, a word, and really only a word, about academic freedom. This speech really doesn't deal with the concept of academic freedom specifically, but it's worth noting that academic freedom and freedom of speech are not quite the same thing. The First Amendment prevents the government, including any public institution, from taking actions that would impinge upon a person's right to express a certain viewpoint as a citizen. And it dates back to the founding of the country. Academic freedom is a more recent addition to American jurisprudence, and it kind of made its appearance around the turn of the prior century, around 1900. It gives scholars the right to pursue their profession, including teaching, research, and other aspects of scholarly work, according to the standards of that profession, without fear of being punished for their methods. It's different from freedom of speech because it pertains specifically to the academy's right to pursue knowledge in a scholarly way, in the classroom and in the research arena. But back to freedom of speech. In the purest sense, the concept sounds fine, very democratic and easy to enforce. Just because someone's upset about speech isn't reason enough to silence it, etc. But of course, it is constantly complicated and messy because what is considered disagreeable or the minority view, changes over time. Many beliefs we now see as the bedrock of our culture, many aspects of civil rights law, for example, used to be the minority view. The court's adherence to First Amendment protections helped to ensure that these views were heard, even though they were often contrary to state and federal law at the time. Many of them were called unpatriotic, un-American, and then these minority ideas gained traction throughout the public sector, and more people began to discuss them. Minds were changed, and eventually laws and policies were changed. That's the way we want the First Amendment to work. But as we'll discuss, it's a double-edged sword, and it doesn't always work that way. So now we have a general sense of what the First Amendment protects. Let's get a sense of what it doesn't protect. The courts have established a set of explicit exceptions to freedom of speech. These are things that the government can regulate. The government can actually stop you from saying these things or punish you if you do. As you can imagine, the list is pretty short. First, there's the true threat. A true threat is a series of words that tend to incite, and I'm quoting from a case here, tend to incite an immediate breach of the peace. Now, the Supreme Court has not specifically defined a test for what makes something a true threat, but here's a general definition. A true threat is a statement meant to frighten or intimidate one or more specific people into believing they will be seriously harmed by the speaker or by someone acting on behalf of the speaker. And because the court has been pretty general in defining a true threat, various federal appellate courts have taken it upon themselves to define it more specifically. And there is a circuit split on this, meaning some federal courts think this and some federal courts think that, and the Supreme Court has not yet clarified it. But as best we can tell, the test is that if a reasonable person would interpret that statement as an immediate threat, then it can be punished or regulated as a threat. But again, the standard depends upon the surrounding circumstances. You have to put yourself into that circumstance to properly decide the issue. True threats also don't include statements that are made as a joke or hyperbole. For example, in 1969, an 18-year-old anti-war protester was arrested at an anti-war rally for telling the crowd, quote, "If they ever make me carry a rifle, the first man I want to get in my sights is LBJ," end quote. He was prosecuted for threatening to kill the president. But the Supreme Court held that his statement was hyperbole. It was intended for effect, and it was not a true threat. Of course, there are many criminal statutes that also prevent true threats. Extortion and the like. You can't use the mail to convey a threat or things like that. So true threats are not protected. Next, the First Amendment does not protect incitement to imminent lawless action. Incitement to imminent lawless action. So if I were to stand up here and say, right now, let's all go and burn down the president's house, that is not protected speech. It is telling people to do something right now, imminently, that is illegal, lawless. But note, the court has distinguished between advocating for lawless action at some random future time and imminent lawless action. To be an exception to freedom of speech, you have to be advocating that the listener do something illegal right now. If instead I were to say, lawyers should all be punched, I am not defining any time for my assault, and it's not likely that everyone would march out of here and immediately attempt to punch me. At least I hope not. So that kind of advocacy at some future time, random advocacy that doesn't incite imminent action, is protected. It's the defining of an illegal act and an imminent time frame for doing it that is not. And for the record, let's not all go burn down the president's house either. Third on the not protected list is the entire category of intentionally false statements of fact. Now, in this day and age, we have to be careful with that category. In order for a false statement to not be protected, you have to know that it is provably false when you say it. And that is a hard thing to prove. Also, many people nowadays mistake statements of professional opinion for statements of fact. When one professor disparages the work of another professor, calling it quackery or nonsense, that's protected speech. It's a statement of that professor's professional opinion. It's not provably false, and it certainly wasn't made with the intent to lie. Now, the context where this comes up most, of course, is in the political arena with political statements, as you can well imagine. We could spend hours simply discussing whether some demonstrably false statements made by certain members of the government in public are in fact protected by the First Amendment, or if they're not. It's a fascinating time for that kind of a debate, but we would never get out of here. More often, so far, the courts have dealt with demonstrably false statements from the perspective of statements that are made about the government rather than by the government. Most such speech has been found to be protected, as these are matters of public concern. So these things are found to be protected, usually unless it's provable that the speaker intended to lie to the audience. Also not protected is any speech that violates a copyright. If I were to get up and plagiarize the entire text of my talk without attributing it to whoever it was who actually wrote it, then my speech isn't protected by the First Amendment. And indeed, the writer could sue me for violation of copyright. So copyright law attaches to literary works, music, dramatic works, choreography, pictures, graphics, and sculpture, movies, audiovisual works, sound recordings, and even architectural designs. Anything that is original and that is in some sort of tangible form. That stuff is subject to copyright. Now, of course, copyright law has exceptions too. And the most widely used one is a concept called fair use. This, too, could be the subject of its own lecture, and so I'm not going to get too much into it right now. But in general, the concept of fair use allows for some free use of another person's copyright. And it applies where the new use somehow transforms the work so that it is looked at in a new way or for a new purpose. Oftentimes, courts find fair use where someone uses a work in order to make fun of it, like a parody in some way. Also, fair use could apply if you just use a tiny little bit of the work, almost so that it's not recognizable. But in general, just using a copyright work without permission could land you in a lawsuit, and free speech is not going to be a good defense in that lawsuit. The next category of unprotected speech is obscenity. So here's a doctrine that has, as you can imagine, changed somewhat over the years. Society's norms have changed, what's considered to be obscene and what is not. The best known line about obscenity comes from Supreme Court Justice Potter Stewart, who said, "I know it when I see it." And that was not exactly helpful to the cases that followed it. So after Stewart's definition, the court developed eventually a three-part test for determining whether certain speech is obscene. Part one is, would the average person applying contemporary community standards view the speech as applying to, quote, the prurient interest? Part two, does it describe in an offensive way sexual conduct or excretory functions? And part three, does it lack serious literary, artistic, political, or scientific value? That's the test. These standards were set up by the Supreme Court in a case called Miller versus California in 1973, and it was designed to change with community standards. As standards change, wherever the bar would be for obscenity would change. But it's a high bar. To be found protected, the work has to really have no other value, no other artistic value. And it's hard if you put yourself in the position of a lawyer arguing that that speech is not going to be protected, you're always going to have a defendant who's saying, this speech has value. It has artistic value or some other kind of value in society. So it's a hard case to prove. Notably, child pornography is not protected, not ever. It is illegal to possess and can always be regulated by the state. It doesn't fall within the three-part test. It is not subject to a First Amendment defense. It has its own exception. Child pornography is never protected. Finally, it's worth noting that the law about what a public employee can and cannot say in the course of their job responsibilities falls into a different strain of the law around freedom of speech. Without getting into too much detail, there can be reasonable parameters around what public employees do and say as part of their jobs. So those are the exceptions to freedom of speech. But among these exceptions, it seems like one is missing, right? Hate speech. Where's the hate speech exception? That can't be protected, right? Well, like most things in law, the answer to this one is it depends. No court has, to my knowledge, recognized a straightforward hate speech exception to the First Amendment. But this doesn't mean we can't prosecute people who use it. For example, under Michigan law, we have an ethnic intimidation statute. For those who will look this up later, it is MCL 750.147B. Under that statute, anyone who, and here's the quote, maliciously and with specific intent to intimidate or harass another person because of that person's race, color, religion, gender, or national origin, does any of the following: causes physical contact with another person, damages, destroys, or defaces any real or personal property of another person, or threatens, and here's the speech part, threatens by word or act to do one of the other two, commits a felony, punishable by 2 years of imprisonment or a fine up to $5,000, or both. The victim of an ethnic intimidation crime may also bring a civil action to recover up to triple damages and attorney's fees. But the statute isn't perfect, and it's hard to prosecute under. The main problem is in the very first sentence that I just read. By its terms, the crime is limited to people who aim to intimidate another person. That means that the hate speech has to have a specific, definable target, an actual person. Thus, although you could prosecute someone who writes a racial slur on a student's dorm room door, for example, it is harder to prosecute somebody who writes that same slur in a public bathroom. Also, you have to prove that the person who was speaking or uttering the threat did it maliciously. That means with the actual intent, and this is the legal definition of malicious, the actual intent to intimidate or harass. That is incredibly hard to show, because in court, of course, the defendant is almost always going to say that they didn't mean anything by their hateful words, that they were joking, that there was some other reason. So it'll be up to the jury, and it'll be up to their factual interpretation to say whether the prosecution has proven that the ethnic intimidation statute was violated. So that statute doesn't protect against all hate speech, and there are some loopholes in it that severely tie the prosecutor's hands, and there is no hate speech exception to the First Amendment. But on the positive side, through the history of our country, there are countless examples of where unpopular speech, and particularly speech on college campuses or by college students, has helped to make change, to expand the country's jurisprudence, to align more closely with the values of diversity and inclusion, and has actually challenged and changed public policy and foreign policy in ways that it's worth remembering. Excuse me. Importantly, the first mass act of civil disobedience on a college campus happened, it's probably not the first, but the first sort of recognized movement happened at UC Berkeley in 1964 and 1965. At the time, on-campus political activity was limited to student Democrat and student Republican clubs, and that was it. The administration did not give funding nor allow other types of student organizations to persist. After a peaceful sit-in, where students demanded change, close to 800 students were arrested, proclaiming their rights to peacefully speak and assemble in a number of different ways. Eventually, university officials slowly backed down, but it took over a year. This multi-day protest became known as the free speech movement, and if you Google free speech movement, pictures of UC Berkeley from that era will come up. A few years later, the mass protests against the Vietnam War provide another easy example. Several college campuses staged sit-ins and protests nationwide, expanding the national conversation about the war and ultimately turning the tide of public opinion on the topic. And in Greensboro, North Carolina, the lunch counter sit-ins that would change American history in the civil rights movement began with 4 teenagers who walked up to a Woolworth lunch counter in Greensboro, North Carolina, and refused to leave. Those teenagers, Ezel Blair, Franklin McCain, Joseph McNeil, and David Richmond, were all students at North Carolina Agricultural and Technical State University. They took their action on February 1st, 1960, and within 3 days, they were joined by about 300 others. By summer, the sit-ins had spread to more than 50 cities, and the lunch counters were rapidly desegregating. The actions of these teenagers, in turn, led to the creation of the Student Nonviolent Coordinating Committee, which itself played a major role in the freedom rides and in voter registration efforts across the South. That momentum also contributed to the passage of the Civil Rights Act of 1964, which outlawed segregation in public spaces. At Columbia University in 1968, students staged a protest where the university aimed to affiliate with a weapons think tank and construct a segregated gym. And their protests also were able to turn the tide on that decision. And right here, EMU's campus was home to several peaceful demonstrations, sit-ins, rallies, and speeches during the civil rights movement of the 1960s. EMU students played an active role in the movement. There were student marches on campus. The students held teach-ins to discuss racism and how to end it, as they do today. And there were a number of movies and meetings to discuss the Black Panthers and relations with the police. There is actually a great picture in the archives showing Pierce Hall in 1969, packed with students discussing the Black Power movement. And of course, EMU students show that advocacy every day today when faced with challenges both here and outside. Speaking up, speaking out has a proud tradition on our campus. So in theory, at least, the law around freedom of speech was designed to allow and support these kinds of actions and to be expansive, protecting speech wherever possible so that people advocating for change have a fair chance to be heard. But of course, what's happening with folks like Richard Spencer is that free speech, this wonderful democratic tool, expanding discourse, is being wielded as a weapon to try to send the country back to a more divisive time, arguably a time to which few, if any, of us would like to return. These views are views that many of us thought we wouldn't see again in our lifetimes. And yet, free speech protects these guys too. One of my idols in the law is constitutional scholar Erwin Chemerinsky. He is the dean of the law school at UC Berkeley. And he says on this, quote, "There is no way to empower a government or campus administration to restrict speech without allowing for the possibility that tomorrow it will be our speech that is restricted. Is that rain? Whoa. That is dramatic. All right, I'll speak louder. But just because that is the law doesn't mean that we can't regulate speech at all. As it turns out, we can regulate speech. We can't just do it based on the content of the speech. Reasonable regulation of speech has been accepted throughout the nation in various contexts. Here is how public entities regulate speech legally. It is called a time, place, or manner restriction. Has anybody heard of time, place, and manner restrictions? Excellent constitutional scholars among you. They were established by the Supreme Court in 1941 in Cox versus New Hampshire. Simply put, state and federal governments, and there's lightning too, may place reasonable restrictions on the time, the place, and the manner of the speech. That is, that we can control certain parameters around the speech in order to promote order. Not to ensure order, of course, but to promote it. We can regulate in order to regulate traffic flow, preserve property, protect the environment, and to provide for the administration of justice. Whether a time, place, and manner restriction is reasonable is, of course, subject to a four-part test that the Supreme Court articulated. Here's the test. The regulation has to be content neutral, can't be based on what's being said, narrowly drawn in order to meet this specific circumstance, serve a legitimate educational interest, and four, it needs to leave open alternative channels of communication, other ways of doing it. That means, for example, that although someone may have a right to stage a protest or a speech on the public street or sidewalk, a city or a university could prevent trucks with sound amplification from playing music in the middle of the night. Does that make sense? Particularly interesting to universities using the time, place, and manner restrictions is the place aspect of this. In constitutional jargon, it is called the forum, perhaps hearkening back to Roman days, the forum. The forum is wherever it is that the speech is taking place. As it turns out, we have several kinds of forum or fora on a university campus. We have areas that are and have been traditionally open to the public all of the time. We also have classrooms. We have dormitories and administrative buildings. Ultimately, how public a place it is determines the level of regulation that we can put around it. For example, we do have sidewalks and public streets that pass through the campus community. These are places that, since time out of mind, have been used for purposes of assembly, communicating thought between citizens, discussing public questions, whatever. These are called traditional public fora. And I think the example of a traditional public fora that is typically used in court is the National Mall on Washington, D.C., just right in the middle of where, all of the protests take place. Because society expects that people will move in and out of these spaces at will throughout the day, and we have no special control over them, courts will rarely enforce a regulation on speech in such a public place. Then there is the designated public forum. This is government property that has not traditionally been regarded as public, but has been intentionally opened up to the public for public discourse. Think of our football stadium or Pease Auditorium or things like that. These are places opened by the government to certain groups or dedicated to the discussion of certain topics. Just as with a traditional public forum, it's pretty hard to regulate speech when you've invited the public in for those purposes. But then as the venues get smaller, the universities or the state's ability to regulate increases a little bit. The next category is the limited public forum. These are places where the topics of conversation are limited to use by certain groups or dedicated only to the discussion of certain topics. Courts have brought up, in the university context, they've brought up bulletin boards as belonging in this category. Here, the government need not allow people to engage in every type of speech, and may also exclude a speaker who is not a member of the class for whose special benefit the forum was created. Restrictions on these places are upheld so long as they don't discriminate based on viewpoint and are reasonable in light of the purpose of the forum. So yes, if we have a students-only bulletin board and someone posts something on it who's not a student, the post can be taken down. It can be regulated. Then finally, on campus, we have many spaces that fall into the category of non-public forums. Non-public fora are places where there is evidence that the government did not intend to create a public area, where the nature of the property itself is inconsistent with expressive activity. Examples include our administration buildings, offices, and classrooms, of course. And of course, classrooms host much expressive activity, but we don't invite the public in the middle of class. It's raining on me. That is what makes a classroom a non-public forum. So the variety of forums, or fora, can provide a guide somewhat to freedom of speech on campus. Yes, there is a right to speak. It's totally raining on me. Oh, this is great. There is a right to speak on a university campus, but there is no right to come into a professor's classroom and shout them down. So what do courts view as acceptable strategies when regulating on campus? Well, let's get back to Richard Spencer and his speech tour from last year. First and foremost, proper use of time, place, and manner restrictions. Universities have successfully required permits, notice periods, sponsor requirements for outside speakers, free speech zones, although I think the Michigan legislature is working on that, limits in terms of the duration and the frequency of speaking, and they've properly banned the rental of some spaces during exams because it's just too disruptive. And that has been upheld. For example, in terms of fora, when we talk about places, Richard Spencer spoke at MSU, and he did speak there. Does anybody remember where he spoke? He spoke, and just because you're so far back, he spoke at the Pavilion for Agricultural and Livestock Education, which is hardly in the center of campus. To be fair, his camp had negotiated that location with the school. But it by no means was in the center of campus. Other cases involving K-12 schools have somewhat expanded the realm of things that can be regulated at the school. The Supreme Court has upheld regulation and punishment for speeches involving lewd and obscene content or conduct that substantially interferes with or is contrary to the educational mission of the school. And that definition has become squishy over the years, or a speech that openly promotes drug use. For fun, you can look up the Bong Hits for Jesus case. For those of you who know that, look it up when you get home. But before we get too excited, all of these other regulations have again occurred in the K-12 area. They have not yet been really applied to the university context. Restrictions that have been tried and struck down also leave a trail of litigation behind them. For example, in the late 1980s, the University of Michigan adopted a hate speech code saying that there cannot be speech that, quote, demeans or stigmatizes anyone based on race or gender. And then a sociobiology student challenged the law. I hope my light holds out. He challenged the law saying, I want to study whether there are inherent differences between men and women. What if my research conclusions are deemed to be stigmatizing on the basis of gender? After a lawsuit, the hate speech code was declared unconstitutionally vague. And while it existed, it mostly was enforced against the very students that it was designed to protect. Richard Spencer's own lawsuits against MSU, Penn State, and Ohio State were nearly identical to one another. Like Michigan State, Penn State and Ohio State refused to rent space for Spencer to talk, citing security concerns in the wake of Charlottesville. Michigan State based its denial on Charlottesville, and Penn State issued a statement saying, quote, "The First Amendment does not require our university to risk imminent violence." And I'm sure they chose those words really carefully based on, true threat and et cetera. Ohio State response noted, quote, "a substantial risk to public safety as well as material and substantial disruption to the work and discipline of the university." All three were sued, Michigan State in September and the other two in October, within just a few days of each other. And the complaints are mirror images of each other. All three were filed by the same attorney and all allege, quote, "violation of plaintiffs' First and 14th Amendment rights to free speech." The complaints charged the university with unconstitutional viewpoint discrimination and content discrimination in the form of the Hecklers Veto. Each complaint asked for injunctive relief, simply that Spencer be allowed to speak. He wasn't seeking damages or anything. And all three complaints cited the same Sixth Circuit, and we are in the Sixth Circuit, that's where Michigan is in terms of federal courts, a decision. And the Sixth Circuit decision, it was called Bible Believers versus Wayne County, reaffirmed in this circuit the federal court's view that a threat of violence by a person other than the speaker is not enough to overcome the speaker's right to speak. That decision was decided not only by the Sixth Circuit, but the Sixth Circuit sitting en banc, meaning that all 16 judges of the Sixth Circuit heard the case all at the same time, and that was the decision that they reached. As part of that holding, the court said the imminent use of violence or lawless action, where there is no evidence that the imminent use of violence or lawless action is likely, the speech is constitutionally protected and must be allowed to proceed. Spencer's camp claimed that because the universities were afraid of violence from others and not from Spencer himself, their attempts to stop his speech were unlawful. Also, the complaints cited a Supreme Court case to make the point that Spencer himself, or his camp, could not be made to pay for any increased police protection due to threats of violence from others at his proposed event. In a 1992 case called Forsyth County versus Nationalist Movement, the Supreme Court found that speech cannot be financially burdened any more than it can be punished or banned simply because it might offend a hostile mob. And therefore, the speaker cannot be made to bear the cost of extra security that might be needed to keep the peace at his or her speech. For this reason, as various universities prepared last year to deal with the prospect of several divisive campus speakers, many of them spent large amounts of money adding the security forces that they deemed might be necessary to keep order. As a case study on this, we have Spencer's speech at the University of Florida. After initially denying Spencer's request to speak on September 12th, the University of Florida ultimately scheduled his speech for October 19th, 2017. In the run-up to the event, the university took a number of actions in an attempt to secure the campus and put forth its own anti-Spencer message. It spent over $500,000 for enhanced security, including 500 law enforcement officers for the venue and the surrounding Gainesville community. It developed a comprehensive Q&A document answering community questions about why he was being allowed to speak, why he was not being charged for the extra security, what security precautions were in place, and what expectations the university had for the day of the event. It published a press release about the event highlighting that no one at the University of Florida invited Spencer to speak, no one at UF is sponsoring the event, the racist ideas espoused by this organization and this individual conflict with the values of our institution. It released a personal message from the university president, Ken Fuchs, reiterating the university's commitment to diversity and inclusion, its hatred for Spencer's ideas, and its commitment to safety and security on campus. Fuchs urged the campus community to stay away from Spencer and his followers on the day of the speech, denying him further visibility or attention. It also encouraged the campus not to let Mr. Spencer's message of hate go unchallenged, and to be understanding and caring and supportive of each other as the event approached. Fuchs also recorded, and I think this is still online, a video message saying all of those things. Students also planned a competing event, a virtual assembly featuring a series of videos and performances in an attempt to open up the dialogue of race relations, cooperation, and diversity. The university closed surrounding buildings and secured its resident halls in the area. Law enforcement created a list of prohibited items, including torches, masks, and weapons of any kind. Further, and I know it seems like a long list, and it was just astounding everything that they did. At the request of the county sheriff, Florida Governor Rick Scott issued an executive order declaring a state of emergency on the date of the speech to provide for enhanced coordination among state, county, and municipal agencies, which could be called upon to assist law enforcement at the university. A local brewery also tried to give away free beer to patrons who turned in tickets for the event to try to get the supply of tickets off the street. It was a great idea, but the stunt unfortunately did not succeed as Spencer's group reasserted control over the ticketing to the event. But the event went forward. Spencer was heckled throughout the speech while hundreds of protesters outside carried signs and chanted, "We don't want your Nazi hate and Nazi scum off the streets." The protest was relatively peaceful, and there were no reports of serious injuries during or after the event. Spencer's request to the University of Michigan ultimately fizzled after Spencer decided mercifully to end his college tour, at least for now. But the U of M Board of Regents held a public meeting after the request in November 2017 to discuss their thoughts on the matter. And the regents took various positions on the issue, and not all were in agreement. But one regent appeared to sum up the thoughts of many when he said, and this is a quote, bear with me, "The only thing worse than Richard Spencer being on our campus is stopping him from being on our campus. We could do the easy thing, others have. We could ban Richard Spencer, everyone would celebrate, the board would be cheered, President Schlissel would be applauded, but we would be dancing on our own graves, and on our tombstone would read, 'Here lies the University of Michigan, afraid to do the right and difficult thing. It compromised its commitment to the Constitution and died failing to live up to the bedrock value of free expression that is essential to our mission as a great university.'" End quote. Again, these are lofty ideas, and they sound right, but they don't make us feel any better about allowing hate on our campus. When I talked to students last year about freedom of speech, they didn't want to hear the constitutional basis of the doctrine and why it's important. They were angry, and they wanted to know, and I don't blame them a bit, why they had to live with racism and other divisive speakers and conduct here, in this place, in this center that is devoted to scholarship. There's no easy answer to that. As a university official, I can't tell you exactly how we will react when we are faced with these issues. But I am here to tell you the legal precepts that we use to guide our thinking when we make these decisions. It is bedrock law that we can't stop a divisive speaker from renting public space on our campus or passing out leaflets in public. But we can place parameters around it. We can carefully assess what it will take to maintain safety and order. And more important than anything, we don't have to take the speaker's message lying down. We can loudly and often proclaim our values as a campus, as a university. As they say, answer speech with more speech. Principles of academic freedom are founded upon reasoned debate, and so is the First Amendment. So speak your mind and be heard. That is why you're here, and that is how you help to contribute to our campus community. Thank you very much for having me. Sure. Oh, because of the rain. Because of the rain. I was like, oh, did we move? Okay.
Yeah, just have a change of scenery, but yes, hopefully it's dripping.
So I'm happy to entertain any questions. Unless you're super eager to go back out into the rain this evening.
Willingly identified himself with several of these groups that are known to, like, literally have been observed going out, directly causing violence. So, like, my thing was, when does the individual of Richard Spencer, like, does he always have to be the one literally going out and punching people? Or if he is part of, let's say, like, a literal organization that also goes out and
punches people regularly?
Yeah, will those be considered one entity? Because you said as long as Richard Spencer isn't the one doing the violence, you can't prevent him from speaking because it's another group.
Gotcha.
Is it literally on an individual basis, or is there a group continuity?
Gotcha. So for those who didn't hear the question, so I made some reference to as long as the speaker isn't the one advocating the violence, then the speech is somehow protected. And the question is it limited to that individual, Richard Spencer himself, who has to be inciting the violence? It's a great question. And I think, for example, if there is enough reason that a court has to say, you know what, this particular, wherever they go, they walk up on stage and say, we're going to incite imminent lawless action. We're going to burn down this person's house right now, follow me, that kind of thing, where this group, no matter who is speaking, would be saying something that's not protected, then I think a court would have a hard time not viewing that as a true threat or incitement to imminent lawless action, even if it's not the head man himself. But that's a great question, because again, it depends on the circumstances. And people, some of the Supreme Court law that grew up around the Ku Klux Klan, there's a case called Brandenburg, where just that is kind of one of the cases that gave us unless it's going to happen right now, the lawless action, then it may still be protected speech. So there were that case basically said, this is the Ku Klux Klan. They leave disaster in their wake wherever they go. This particular incident, we must have been correct, us, the state, in regulating this speech. And the court actually said, no, it wasn't an incitement to imminent lawless action in this circumstance. Thanks. Other questions? All right, thank you very much.